Sir, please state and spell your name for the record.
My name is Scott Saul, Scott-Saul.
What do you do for a living, sir?
Attorney in private practice.
Okay, do you recognize the defendant in this case?
Yes, Mr. Hollis.
Mr. Hollis, is that Billy Hollis?
Yes.
Did you at one point in time represent Mr. Hollis on the matter before this court?
Yes.
Now, I don't want to go into any discussions about the facts of the case or anything of that nature, but do you understand he's filed a motion about an alleged prior agreement?
Yes.
Going through that, did you ever have, who was the prosecutor of the case whenever you first had the case?
Mr. Arnold.
Did you partake in discussions with Mr. Arnold about possible settlements?
Yes.
What were those? And again, nothing to do with the facts of the case, just the settlement discussions. What did that entail?
We discussed just the nature of the offense here in Cheatham County. Without going into too much detail, to me and to Mr. Arnold, there were sort of two layers to it. There was the theft of the vehicle and the items that were found in the vehicle, also the aggravated assaults as related to the evading. So we had discussions back and forth about that. And Mr. Arnold, as he stated under his testimony, was under the impression that Mr. Hollis had a drug problem. There were some discussions about drug court.
Did he apply to drug court?
Yeah, that was rejected.
Okay, so was drug court an option whenever you were talking to Mr. Arnold?
Not in terms of trying to settle the case, no.
Did he have charges pending or violations of probation pending anywhere else?
I knew that he had an open violation in Parksville, Montgomery County for a felony case. I think he was on a 9-year sentence there.
Did he have any new charges pending?
I later learned that he did have new charges that were pending in General Sessions Court in Montgomery County. And when we were trying to, Mr. Arnold and I were trying to reach a settlement, and that was being communicated with Mr. Hollis.
What kind of a settlement? What all would it have included?
Well, there was a discussion about maybe giving him jail credit for the time that he'd served and some community corrections. But then Mr. Hollis is keenly aware of criminal procedure from his experience in the system. So he was concerned about consecutive or concurrent sentencing, which is a fair thing to be concerned about. So we were trying to work out a global settlement that might entail everything.
Now, we use global a lot in discussions. Does that mean you're trying to resolve Montgomery County cases, the new cases in VOP with this?
Exactly. Mr. Hollis was worried about that, which I think was a fair concern.
What was he, you say worried about it? Was he worried about trying to resolve Montgomery County with this?
Yes, he was concerned that there was the chance that Montgomery County might run his new charges consecutive to this case, or that the possibility that this case could run consecutive to the violation that he had in Montgomery County.
Did General
Arnold, several aspects to it.
Did General Arnold ever make an offer to you about community corrections?
There was, my recollection is there was a split confinement type of offer that involved community corrections. And we were in a position to enter a plea on that here in front of Judge Lockhart Mash, but Mr. Hollis wanted to hold off and wait because he still didn't know what was going to happen in Clarksville. Specifically, he didn't know what was going to happen as was related to the new charges that were still pending in General Sessions Court in Clarksville.
So for the record, if you had a settlement reached in this, would you put it up in front of the judge and entered it?
Certainly would, yes.
Your testimony, is it that Mr. Hollis here told you to hold off because he wanted to see what happened with Clarksville?
Correct. And I recall that we had a discussion. Mr. Arnold and I were at the podium. Judge Lockhart Mash was on the bench that day. And we indicated to her that we wanted to reset the case because of this pending cases that were in General Sessions Court in Clarksville. And Judge Lockhart Mash expressed dissatisfaction with that this case was sort of trailing a case that was in General Sessions in another county, but she granted us the continuance.
Was that in 2024?
Yes.
Okay, prior to General Arnold leaving?
Yes.
Okay. Did you understand, did Clarksville agree to anything as a global settlement?
No. Clarksville, my recollection from the emails is that Clarksville was not interested in doing anything that would possibly be considered favorable for Mr. Hollis.
But for the record, was I the prosecutor of that in Clarksville at that time?
No.
Okay.
No, you weren't.
So a different ADA had said that they were not interested in that with Clarksville.
Correct. The assistant that was believe it was Miss Morgan, I think is,
Crystal Morgan?
yes, I think that was her name.
For the record, was there ever kind of going back to contract law, was there ever a bargain for exchange where ultimately you made an agreement and it was going to be entered into the court at any time?
No,
And that was before General Arnold left?
that's correct.
Was there an offer pending when General Arnold, when he left? Did you have any kind of offer pending when he left?
No.
That's all I have. Thank you.
Mr. Lockhart, you may cross-examine.
Are you sure that it was in 2024? Before Mr. Arnold left, that y'all were in court and Judge Lockhart Mash reset the case?
Yes, because I remember being at the podium with Mr. Arnold talking to Judge Lockhart Mash. Now, we were scheduled to be in court, I believe, on January 14th of this year of 2025. But my brother passed away and his services were in New Jersey on January 15th. So I couldn't be here that day, and did an email exchange with Mr. Stevens in the clerk's office, and we were able to get the case moved to later that month, to later in January.
So you're saying you were not in court on January the 14th of this year?
Correct. I
Right.
was traveling to New Jersey for a funeral.
All right, and were you in court on January the 28th of this year?
Can't recall if I was here for Mr. Hollis on the 28th, or if there was an issue with transport. There were a couple instances where Mr. Hollis, he was bouncing back and forth between being transported between here and Montgomery County for court up there. So I really couldn't tell you that, Mr. Lockhart, if I was here on the 28th for him or if it got reset because of that. I do know in around that time frame, I learned that Mr. Stevens was not interested in doing a plea under the same parameters that I had talked about with Mr. Arnold.
Now, was that in 24 or 25?
That would have either been December of 24 or January of this year. It would have been in that. It was after Mr. Arnold left. And I remember having a discussion when I received the new offer. I want to say it was in January, but I can't say for certain. That when I received the new offer, I said to Mr. Stevens, I understand that we're not in the neighborhood of what was previously discussed, but in fairness to Mr. Hollis, he was thinking he had the chance to maybe resolve this case in a certain under a certain sort of neighborhood of a sentence. And the new offer that was made was much different, and that I was going to have to spend some time with him to try to make him understand why it changed.
The original offer was 6 years community corrections, is that correct?
I think there was an original offer of 6 community corrections, but he was getting jail credit. So if I remember right, I was trying to double dip a little bit for him to get him credit for the time served and then the balance on community corrections. But then there was, of course, we had what we're trying to work out with Clarksville.
May I approach?
You may.
Ask if you can recognize that handwriting.
Yes,
Is that your writing?
yes,
And do you recall providing that to Mr. Hollis?
yes.
And what does that reflect the offer was?
He had an offer of 6 years community corrections, plead to 1 misdemeanor and 4 felonies, dismiss the remaining 21 or dismiss 21 other counts.
And when were you first notified that that offer had been revoked and the new offer was 20 or 25 years.
I think we're getting a little crossed up, Mr. Lockhart. And what I mean to say is, this was an early offer as we were going back and forth. And then the offer had changed from Mr. Arnold as it pertained to what was going on in Clarksville. And we weren't able to enter this offer. And Mr. Hollis was always very keen on wanting to make sure whatever we did in Cheatham County was taken into account with Montgomery County. He didn't want to resolve any of this piecemeal.
Well, I understand, but that does not show that it's contingent on Montgomery County or anything else. That's a settlement offer you relayed to him that was pending.
I was conveying to him what the offer was at that time. And
Right.
he didn't, let me tell you something. If he wanted to accept that at that time, I would have got his name on the docket and we would have entered this plea, because that was a sweetheart deal.
So you didn't tell him something to the effect you wouldn't be doing your job as an attorney if you didn't check on Montgomery County first?
Now, he asked me about Montgomery County and I said, I don't know what Montgomery County is doing. I don't have that case. And he mentioned, well, I have case pending up there. I don't want to do anything that's going to mess up my case in Montgomery County.
And did you tell him, based on your experience, that that's something he should check on before he entered this plea?
So it would make sense, but I also remember telling him that this offer was never going to be better than this, ever.
I understand, but would you have told him that that would make sense to check on Montgomery County before he enters this offer?
I recall telling him that he should probably take this, but he was hesitant because of Montgomery County. And I said, if you want me to check on Montgomery County, I will. And then I had a discussion with Mr. Arnold about it. And then we realized the full scope of what he had in Montgomery County, because at that time, I only thought he had a probation violation that was pending. I think it was a 9-year sentence. But he also had a plethora of new charges related to evading arrest and some other related things that were in general sessions court. So it threw a monkey wrench into it.
Well, you say it threw a monkey wrench into it. He's testified that his Montgomery County lawyers got a deal worked out for community corrections and treatment.
Yeah, he said that several times, and I've spoken to a Montgomery County attorney that said we didn't have a firm deal whenever I was trying to find out what was going on.
When did you last talk? So you're saying he's lying when he says that that's been worked out and his lawyers told him that's what he's got?
I'm saying that may be the case now, but whenever I spoke to his Montgomery County lawyer, I told him we were trying to get it worked out with the DA, and he said the DA, I remember the attorney saying the DA up there was not happy about the new charges in Montgomery County because he had done the same thing yet again.
But this offer was not contingent upon Montgomery County.
No, this wasn't contingent on Montgomery County, no.
And in January of this year, if he had taken that offer, then he would be on community corrections now, plus whatever Montgomery County.
This offer wasn't available in January this year.
All right. When were you told that offer was not available?
Whenever Mr. Stevens took the case over. But this,
Okay.
but let me state something. I want to make sure we're clear about this. This offer wasn't a perpetual offer. Whenever we found out the full scope of what was going on in Clarksville, and Mr. Arnold spoke to his colleagues in Clarksville with the DA's office up there, the nature of the offer changed somewhat, but Mr. Hollis didn't want to enter a plea here until he knew for sure what was going to happen to him in Clarksville. And if it was going to be a global settlement, he would not do it. And I thought, I understand your perspective, Mr. Hollis. And here we are.
So you say the nature of the offer was changed a little bit. How so? When was this changed to something else before Mr. Stevens made the big offer?
Whenever we had after we had discussions, well, I shouldn't say Mr. Arnold had discussions with his colleagues in Montgomery County that we couldn't get it all worked out globally. And there were yet again more charges pending, new charges pending in Clarksville, so that the offer changed just a little bit.
How so?
I think the length of it changed. It might have gone from 6 to 8, but that's where I was trying to double dip with the jail time.
Would that have been Mr. Arnold that upped it 6 to 8?
It was Mr. Arnold, yeah.
And when was that offer relayed?
I don't know the date, Mr. Locker. I don't know.
Okay. But until Mr. Stevens came in and made a much higher offer,
Right.
the pending offer was either 6 or 6 to 8, based on that tweak you referred to.
It was always, yeah, it was a pending offer that was out there if he wanted to do it, but he didn't want to do it because he didn't know for sure what was going to happen in Clarksville.
You're saying he didn't want to do it, or did he want to check with Montgomery County like you indicated he probably should do?
He didn't want to enter a plea until he knew he didn't want to enter a plea here until he knew for sure what Clarksville was going to do to him based on a plea to these charges here. He didn't want to do it.
And if he's testified, his lawyers told him what they're going to do in Montgomery County, and he wanted to take that offer.
If he wanted to take this offer, I would have got him in here quick because this offer was a sweetheart deal.
Did you try to get him in court to plead on the 6 to 8?
No, because he didn't want to enter the plea because he was still trying to figure out Clarksville.
When did he find out about Clarksville?
Clarksville had told us they weren't going to do a global deal.
I'm not asking that. When did he find out that he did have a global deal? When did he find that out?
He never had a global deal when I was representing that included Clarksville.
If he's testified today that Montgomery County has offered him 9 years community corrections and treatment, you're saying he's wrong.
I'm saying that may be the case now, but when I was dealing with him, that was not the case.
Right? When did he get the 9 years community corrections and treatment in Montgomery County?
I don't know.
Okay. So what he's testified to could be correct.
Could be a lie. I don't know.
All right. So, I mean, are you saying your client's a liar?
Yes, actually,
Okay.
I am.
All right. And so he's lying about having this offer in Montgomery County.
I don't know if he's specifically lying about that. I know that it's part of his statements that he made were flat out lie. Yes.
And when did Mr. Stevens, I guess, revoke or make his offer?
That probably would have been late December, early January is my best recollection of it.
And could it have been late in January or early February of this year?
I sincerely don't know the specific day. It would have been, we've been in the December, January timeframe. It would have been in there. Yeah.
All right. And if he's testified he had an understanding with Montgomery County and wanted to take the plea in January the 14th, do you know of any reason, based on anything you've received in writing, why he couldn't have pled?
There was no plea that was going to be entered on January 14th with Mr. Stevens.
Why not?
Not according to the offer that was, or in the neighborhood it was previously offered. I didn't have anything to enter unless it was, I don't know. Matter of fact, now that I think about it, January 14th, I hadn't actually met Mr. Stevens yet because when I had to get the court date moved to go to the funeral, I was trying to figure out who am I going to have to talk to at the DA's office to make sure it's okay to get this court date moved and explain my situation. So I hadn't actually personally met Mr. Stevens at that point. We may have had some email exchange, I don't know, but I hadn't actually personally met Mr. Stevens prior to the 14th.
Had you talked to him prior to the 28th when it was reset?
Possibly. I possibly did.
All right. And did he tell you he wanted to go ahead and take the offer?
Who, Mr. Stevens? I don't understand your question.
No, not Mr. Stevens. Mr. Stevens wouldn't be taking an offer.
I
Did
know.
Mr. Hollis tell you he wanted to take the 6 to 8, the tweaked offer?
There was no offer available at that time
And why are you saying that?
because Mr. Arnold was gone.
And so when he left, the offer was gone?
Whenever I finally had a chance to talk to Mr. Stevens about the case, he explained to me, look, I'm not going to do anywhere near what Mr. Arnold was offering. I'm in this.
When was
area of
that?
the neighborhood. For probably the 13th time. I don't know specifically. It was sometime in January, most likely.
So whether it was before January 14th or after, you don't know.
Let me say it simply. I don't know the exact day, but there was no plea offer available on January 14th.
That's what I said. It was an offer, but it got tweaked and that it went to 6 to 8.
It was, that's my recollection of it, because I remember thinking, well, maybe we can double dip with the jail time to get it to 8, but really in effect, it would only be 6 in terms of community corrections. It was something, I remember thinking about that.
And as to whether that offer was still on the table in January, you can't say for sure that it was or was not.
It was not. We didn't have the, what I've paraphrased or called the sweetheart deal was not available to us on January 14th.
All right, is the sweetheart deal the 6 community corrections or the 6 to 8?
Either one would have been the sweetheart deal.
All right, and you say the 6 to 8 was not on the table? Why do you say that?
Because I wasn't dealing with Mr. Arnold at the time. I was dealing with Mr. Stevens.
So Mr. Stevens talked about 6 to 8?
He never said 6 to 8, ever.
Well, you said the offer was tweaked to 6 to 8. Who
Mr.
made
Arnold-
that?
Mr. Arnold tweaked it when we were trying to figure
Okay.
out globally what was going to go on with Clarksville.
And as far as whether or not on January the 14th, Mr. Hollis could have pled to either the 6 or the tweaked offer 6 to 8. You don't know if Mr. Stevens told you after that there was no offer.
I don't specifically remember when he told me that, but I know for a fact there's no way that offer was on the table on the 14th.
How? How do you know that?
Because I was dealing with Mr. Stevens at that point, and Mr. Stevens would not have gone from, okay, on the 14th, I would have let him plead to a 6 to 8 to suddenly, no, I want him to serve 25 years. That's beyond reasonable to expect that that's what happened. That's not what happened.
But when did he go to the 25?
Whenever I had my first meaningful discussion with him, he said, look, I want you to understand, I'm not going to be in the neighborhood. I think that was the word he used. I'm not going to be in the area or the neighborhood of what Mr. Arnold was and trying to resolve this case because I have a lot of knowledge of Mr. Hollis from his time in Clarksville in Montgomery County. And because of a variety of factors, that offer is not, I'm not even going to be in the realm of that offer. The offer is going to be 25.
But that's after the 14th of January, right?
I don't know. It may have been just before or just after the 14th. I don't know.
Well, did you go and talk to Mr. Hollis and tell him that the new offer was 25?
Correct. I did.
And you tell him the DA must have it in for him?
I told him the DA was being very aggressive because he had a, how do I put it? He had a keen insight, or he had a lot of knowledge of Mr. Hollis and Mr. Hollis's charges, previous convictions, previous behavior in Montgomery County. And based on that, plus the nature of the charges he had here, which were similar in many ways, that he felt 25 years was a reasonable offer. And I explained to him, I understand your perspective, but in fairness to Mr. Hollis, you have to understand when he was thinking about Cheatham County, he was thinking about something in this range over here, maybe a split confinement, some community corrections versus 25 years in a penitentiary. That's a large difference. I'm going to have to spend some time with him to make him understand why you're being so aggressive.
But no doubt that was after January the 14th. Is that correct?
And I had that conversation with him.
Yes.
Probably, most likely.
Well, I mean, you testified earlier, you hadn't talked to him before the 14th. So I mean, it would
Yeah,
have to be.
I mean, you're asking me to look at it specifically, and I'm saying it was in that same general time frame. Yes.
I'm just trying to ascertain if the offer was on the table on the 14th.
It was not on the table. If there was
Based-
an offer that good on the table, I would have had one of my colleagues, hey, you need to go into this plea with Hollis on the 14th. I can't be there because I got to be out of town.
Well, you've testified it was tweaked to 6 to 8, but you've not said when that offer was taken off the
I
table.
don't know. I can tell you 100% for sure, there was not an offer available to Mr. Hollis on the 14th of a 6 to 8 or a 6. It was not on the table at that time. I know it wasn't.
And is that based on conversations with the DA before the 14th?
I don't recall if it was based on that conversation or based on common sense that if he came at me with 25, he wasn't going to do a 6 to 8 on the 14th. It's one of the other.
Did you know that it was going to be 25 before the 14th?
I don't know. I've said this 17 different ways.
I think we've been down this. I've been patient with objecting.
Sustained is ask and answer.
Did you find out about the 25-year offer after you had met Mr. Hollis or before you had met him?
I met Mr. Hollis several times. When do you mean?
Right, on these charges, was it before you were appointed that you found out about the 25-year
It
offer?
was long after I was appointed. Yeah.
All right, and record indicates you were appointed when?
Probably a year and a half ago or so, something like that. I don't know.
All right. And can you say whether you received that offer from Mr. Stevens before or after January the 14th of this year?
I don't know.
Okay. Did you have anything in your file that reflected that offer? I mean, was there a letter, an email, or?
I think it was initially a phone call. We talked about it, and then he did a follow-up email. And in the email, he talked about what his sort of worst case scenario with the maximum, sort of the maximum exposure if Mr. Hollis was convicted of every last thing and the judge at sentencing ran as much as possible consecutive, sort of like the doomsday scenario.
And did your file have notations as to when the phone call was and the nature of the conversation?
I have to go back and review the file with me. I haven't even billed for this case, so.
Is that something that if the court provides some time, can you look that up so we can ascertain when you had that call?
Sure.
And can you get emails as to when you received emails from Mr. Stevens?
Yes.
All right. I would ask that he be allowed to supplement the record with that, because I think those are important dates in regard to the January the 14th of this year.
Your Honor, if I may briefly ask some questions, I don't think it's relevant. I don't think there was an open offer to where it would matter what happened after January.
Well, let me ask you this question. If there was an open offer, but it was never accepted formally by the defense and conveyed to the state, how is it a binding agreement anyway?
I agree that it's not.
The elements of contract law, if they're applicable to plea agreements, are number one, if there's an offer, and number two, there's an acceptance of that offer. It seems to me that we've been talking about something that isn't relevant, because I'll ask this question, Mr. Saul. Mr. Saul, did you ever convey to the state that your client was willing to accept and did accept the offer of 6 to 8 years or whatever that was?
No, sir.
No offer was accepted, then how can the state be forced to honor an agreement that was never entered into?
Well, according to the case law, Your Honor, the court can look at other factors such as does there appear to be a retaliatory offer or a new offer or withdrawal of an offer based on some bias or prejudice or something that appears to be retaliatory. And there are a number of factors the court can look at in regard to whether they strictly enforce it as a contract that was not accepted, as opposed to something that was retaliation.
Well, your client has never been convicted of anything. He has a pending case, and the ultimate remedy is he sets it for trial. And And then he may get a better result than what this plea agreement is, it seems to me. I don't know. That is the difference between someone who enters a plea and then comes back and wants to redo the plea because of retaliation. The defendant is never required to accept the plea. He always has the remedy of being presumed to be innocent and go to trial. And is that not different than the case law that you're citing?
The case law, you look also at the other factors, retaliation, fundamental fairness, those type things. That's the reason I've been trying to ask to allow Mr. Saul to supplement the record. Our position is he had not received anything revoking the offer. And on the January the 28th court date, he could have pled and taken the offer.
According to him.
According to him.
Your Honor, according to witness testimony that you've heard, including General Arnold, there was no offer. In fact, they previously tried to work this out. And when they talked to Clarksville, they said that we're familiar with his antics, nothing to do with me. I know their ADA said we're familiar with this. He's done the same thing again. We're not going to allow this. So it went back to square one, as General Arnold testified to. It's simply, there was no offer to consider one way or the other. There's no retaliatory. I didn't have this case first. That was the first offer. This is not one where it's, let's have a motion because you had a motion, I'm going to make a horrible offer to you. That was just the first offer, period.
And Your Honor, has been testimony this morning. Mr. Arnold couldn't recall all, but Mr. Saul said the offer was tweaked to 6 to 8. And when you say an offer is tweaked, that's an offer. And what I'm trying to show for the purpose of appellate purposes is that he could have entered that plea on January the 28th, because there's been no testimony other than Mr. Saul saying what common sense dictates he wasn't going to agree to that. There's been nothing filed in writing. There's nothing reflecting that offer was revoked or withdrawn.
Is there a written offer from the state to the defense?
Yes, Judge, there was an email. There was an email. We had a phone call about it, and then we had an email
I'm talking about, was there a subsequent written offer from the state?
regarding the 25. Yes, sir.
No, not the 25. I'm talking about the one that Mr. Locker wants to try to enforce.
No, there wasn't. We
So there
were
was
having
already-
verbal discussions going back and forth, Judge, and
There were verbal discussions, but no written offer.
no written offer, and it was always contingent or hung up on Mr. Hollis's desire to make sure whatever we did here didn't adversely affect what was going on in Clarksville. And if I may add, at some point during this process, Mr. Arnold and I, neither one of us were aware of the fact that he also had new felony charges pending in general sessions. And then we learned of that and we thought, uh-oh. And it was around that time that Clarksville said, we're not willing to do anything favorable because of, he picked up new charges in Cheatham and new charges in Montgomery County, as well as having an open violation. Well, he was on probation. I think it was a 9-year sentence in Montgomery County. So the Montgomery County DA's office wasn't willing to do anything that could possibly be considered favorable to Mr. Hollis.
Well, at that time.
Yeah.
And whether that's different now, you don't
Maybe
know.
it's different now. I don't know.
And whether the offer is in writing, you did have an offer of 6 years community corrections. Is that correct?
That was rejected by Mr. Hollis because he wanted to see what was going to happen in Clarksville.
Now, you testified earlier that when y'all discussed that, and he said he wanted to check on Clarksville, you said you told him that would be a wise thing to do.
I told him that I understood if he wanted to see how it would affect it, I would do what I could. But I also told him, regardless of what I learned, his offer in Cheatham was, in terms of in a vacuum, the Cheatham County offer was never going to be better than what he got at that time. It was never going to be better than that, in my opinion.
I understand, but you said he rejected it.
He
And
did.
actually what he did was talk to you and say he wanted to check on Montgomery County, and you told him.
Yeah, that's a contingency.
Fact of the matter is, he never accepted it.
Correct.
So there was. in my
At that
opinion,
time.
In the whole time that I represented
I
Mr.
sustain the
Hollis.
objection as to the relevance.
Yes, Your Honor. And was that original offer once you found out some things about his past, was it tweaked by Mr. Arnold to 6 to 8 years?
I have a memory of it, of there being some kind of a tweak to it. And I don't know if it was specifically related to that or if it was, there was some issue and about the length of the sentence. And I remember thinking, well, Mr. Arnold might let me double dip with the jail time and shave that off. So we end up back at the 6. And these were just discussions going back and forth, trying to figure out what we could do. But at no time did we have a plea agreement where Mr. Hollis was going to enter a plea here in Cheatham County, where he wanted to enter a plea here in Cheatham County that was rejected by us. It was always Mr. Hollis wanting to see what was going to happen in Clarksville.
And you did testify the offer was tweaked to 6 to 8.
Objection asked.
Yes.
Sustain.
Yes, at some point there was some adjustment.
Question, sustain the objection.
Well, Your Honor, I'm asking based on your Honor's question about whether there was an offer.
And you've asked that question about 5 times today about whether it was tweaked, so I sustain it as being asked and answered.
All right. So other than those 2 offers, was anything else made? Any other offers made?
I don't recall any other offers made by.
I mean, did you go up maybe like to 10 or 12 or something? Anything of that nature?
It's possible. It's possible that I was trying to. It's possible that through a
Okay.
negotiation process, I imagine that's possible there.
And notes in your file and emails will reflect as to when Mr. Stevens essentially took that offer off the table.
Exactly.
That's all the questions I have.
Redirect, Mr. Stevens.
I'll make it very brief, Your Honor. I think we've been around quite a bit.
It's your document.
I'll make it very brief, Mr. Saul. Going back to contract law, was there ever an offer and an acceptance in this case?
No, there's always, I'm not a contract attorney, but there was always a contingency attached to it.
Was there, so were there negotiations with yourself and General Arnold?
Absolutely.
But there was no meeting of the minds that would effectuate a contract that had to be enforced?
No, it was always, in summary, it was always, yeah, but let me check on this other thing.
And in fact, your testimony was that Mr. Hollis himself was not willing to enter this until he knew what he was going to do in Clarksville.
Exactly.
And before you came off the case, nothing was ever agreed upon in Clarksville.
Now, as far as I knew that.
Before you came off the case, Mr.
Before I came off, I was not aware of anything that Clarksville was going to do in terms of running their disposition concurrent to Cheatham.
If you had had an offer with 6 or 8, whatever it is, would you have entered it?
Absolutely.
That's all that I have.
May I approach?
You may.
If you would look at the top paragraph. And does that reflect the date that Mr. Stevens said he relayed the 25-year offer to you?
Yeah, the opening paragraph is, Jake, per your request, I'm providing a written offer of settlement. Please note that this will be very similar to the one previously sent to Attorney Scott Saul on January 27th, 2025.
Right. And so, I mean, based on that, you don't doubt that you found out about the 25 until after the 14th of January.
Yeah, most likely it was based on that. It was after that. I know there was a phone call from Mr. Stevens where we talked about the case, and then he said, let me send you an email that completely summarizes the offer, so you have a written offer.
Right.
Now, when that phone call happened, I don't know, it may have been within a day or two.
But you could check your file.
Yeah, I could check the file.
And we know, at least as far as writing, it was the 27th that he said he conveyed the 25-year offer to you.
Yeah, I mean, according to that email, yeah. To
Well, I mean,
January 27th.
you don't think General Stevens would state that wrong in an email to me, do you?
No, what I just said is, according to the email, it said January 27th.
All right. And you don't have any reason to doubt that.
No.
That's all the questions I have, John.
No redirect, Your Honor. That's
Thank
all.
you, Mr. Sweeney and Stephen.
They did.
State calls Sergeant Matt Farrell.